existing law without changing anything at all, there's an argument that can be made to legalize marijuana. And that's what I'm going to talk about. We don't have to write any new laws. We have the laws we need now. We can get this done without changing any federal law. I don't know if that has anything to do with why these bills have such a low chance of being enacted, but nevertheless. So that's a picture of some marijuana that Boris was talking about, growing a couple not far from my house alongside the road. You can see it there just in all its glory. Schedule 1, dangerous. It'll kill you just looking at it. So,
I'm already dead.
that's what it is. So this is me. I got arrested in 1970 with a gram of marijuana in Iowa City. That's the same year the Federal and State Controlled Substances Acts were enacted. 73, I got arrested with 6 pounds driving in a car in Ankeny. 1978, I got arrested with 100 pounds in West Liberty, Iowa. Got a 5-year prison sentence. 1979, I was arrested with 2 pounds in Newton, Iowa, which I was convicted of a misdemeanor. And 1980, I got arrested with 20 tons of marijuana in Deer Island, Maine. I got a 5-year federal prison sentence for that. In 1984, I was arrested for 800 plants growing in my yard in Miami Beach, Florida. So what happened was that in 1984, I went to the Muscatine County Jail and turned myself in. I was transferred to the Oakdale Classification Center, sent to Mount Pleasant Treatment Facility for drug treatment, told them that I love pot, and was immediately transferred to the state penitentiary where I was locked up in maximum security until I was released to federal custody. I was released to federal custody after 7 months, so that 5-year prison sentence turned into be a 7-month sentence. The federal judge granted me credit for state time, so basically it reduced to 0. So the state sentence just disappeared. So that left me with the remainder of the federal 5 years. When I got to the federal prison, so then they transferred me to Leavenworth Federal Penitentiary, Terre Haute Federal Penitentiary, Talladega Federal Correctional Institute, and finally to Tallahassee Federal Correctional Institution. When I got to Tallahassee, the warden, for some mysterious reason, took 2 years off my sentence and calculated my release date 2 years sooner than it should have been. So that took it down to 3 years. I got out a year and did a year on parole, so I did 2 years in prison and a year on parole out of all of that. So while I was on parole, I went to school and got a paralegal degree. I started studying law around 1980. I ran the prison law library in Tallahassee, and I got a paralegal degree when I got out, and I've been studying law ever since. So these are 3 administrative petitions I filed with the DEA, and each one of them I took all the way to the U.S. Supreme Court. So if I sue somebody, they know they're in for a long time. I'm going to tie them up in court for a long, long time, and I'm going to be very vigorous, and I'm not going to quit until I get to the last court in the United States. So in 1983, I filed this petition for a religious exemption from the Controlled Substances Act based on the religious exemption for peyote. Went to the U.S. Supreme Court in 1990. The attorneys that represented me was the same law firm that Chief Justice John Roberts worked for at the same time that law firm represented me, Hogan and Hartson. And they just did that for free. They just thought it was a good case and they wanted to be involved in it. Then when THC was moved from Schedule 1 to Schedule 2 in 1986, I filed a case in 1993 saying the plant has to follow. You can't make this stuff without a plant. And the end result there was they said, we don't get it from a plant, we make it synthetically. So you lose. And then the last one, there is a petition that I filed in 2002. And that one went to the U.S. Supreme Court in 2013. And that one was based on science. You know, we said the DEA should look at the science, and the science shows it has medical use. And we lost, like everybody does when they make that argument.
Why?
Because there's a difference of opinion, and as long as experts, the way they do it is testimony. So if the testimony is some experts say it does and some say it doesn't, then the status quo prevails. If you want to change the status quo, you have to show a substantial majority, and that has not been done successfully in any court where this has ever been tried. Not saying it can't be done, just saying a lot of people have tried.
It takes a lot of money to do that, right? You have to get so many experts out and to testify, basically.
Right, yeah. It was last done in a criminal, well, it's done frequently in criminal cases, and so the defendant will have an appointed attorney, and they'll bill the court for the cost of the expert witnesses. That's how they get around it. But for somebody who's not a criminal defendant, yeah, it would cost a fortune. Absolutely. So those are the three cases I took to the U.S. Supreme Court. Now this one is one that Normal filed in 1972, and I joined it in 1985. And in 1988, the DEA's chief administrative law judge said marijuana in its natural form is one of the safest therapeutically active substances known to man. And ruled that it should be transferred to Schedule II. The DEA overruled him in 1989, and the U.S. Court of Appeals upheld it in 91 and upheld it again after a rehearing in 1994. So in 1994, the ruling there that judge made was invalidated. And of course, the next 1996, California enacted a medical marijuana bill. So that let the states know right there wasn't going to be any federal solution to this. That was so absurd to get a ruling like that from the administrative law judge, and then for the court and the DEA to overturn that. I don't think it's any surprise 2 years later California puts this on the ballot and legalizes it at the state level and just says there is no federal solution to this, we'll just take this matter into our own hands. And since then 40 states have followed. None of them has addressed federal law. So after that case was disposed of, John Getman filed a petition in 1995, John Getman in High Times Magazine, and when the DEA denied the petition, and this was financed by High Times Magazine, so Boris's comment about how expensive this is, that was how this case developed. On appeal, they said, you don't have standing to appeal. You don't have an actual injury here. They said, we could make lots of money off of this. And the court said, that's just speculation. You have to show an actual injury. You can't just say you think that you have been injured or that you would make a lot of money. And so they dismissed that. So that Getman came back in 2002 with a bunch of people, and I was one of them. So in 2002, we formed this coalition and we all filed this petition, and it was based on the same stuff that was filed in 95 plus any new science that had occurred in between those dates. So at this time, in 2002, there were 8 states that accepted the medical use of marijuana. And in the petition, the petitioners, which I didn't write, I was just this was all out of my hands. I had no control over the arguments that were being made. The argument that was made was that these 8 state laws show medical efficacy, okay? That's not federalism, okay? Federalism means the states have some rights. So to introduce a state law as evidence of medical efficacy is not federalism. I want to make that clear. That was an argument based on science, not law. So while that was pending, the U.S. Supreme Court decided a case, well, let me go through this timeline. In 1967, we adopted the Single Convention on Narcotic Drugs, and marijuana was included in that treaty. We enacted the Controlled Substances Act to comply with the treaty, and we put marijuana in Schedule 1 in compliance with the treaty. The unusual thing is that the Uniform Laws Commission drew up something called the Uniform Controlled Substances Act with the help of the U.S. Department of Justice, and they gave each of the 50 states their own scheduling process. So if the federal schedule was one schedule to rule them all, it wouldn't make any sense to have each state have their own scheduling process. So this is federalism, and that shows you how it was incorporated at the time into the law, that it was well understood that it was federalism. In '72, and when they put marijuana in Schedule 1, it was so controversial, they had the Schaefer Commission, which did a study and recommended that marijuana be removed from the Single Convention. And when that was rejected, Congress didn't respond to that. Normal filed that petition, which resulted in the '88 ruling from the DEA Chief Administrative Law Judge. '86, pure THC in a pill moved to Schedule 2. '87, Grinspoon versus DEA said that accepted medical use and treatment in the United States is intrastate medical use. And intrastate medical use means not outside the borders of that state. It means that marijuana is accepted for medical use in a state, and that is accepted medical use and treatment in the United States under federal drug law. Now remember, in '87 there were no state medical marijuana laws, so nobody connected the dots. 88, DEA Administrative Law Judge says reschedule marijuana. 91, the U.S. amends the Psychotropic Convention to take THC out of Schedule 1 of the International Psychotropic Convention and place it in Schedule 2 of that convention. And this was done because they wanted to move THC to Schedule 3, and they felt the treaty was an impediment to that, so they had the treaty amended. The United States moved the International Narcotics Control Board to reschedule THC. So anybody that wants to talk about marijuana, we have the whole entire example of how to get the job done here. We know how to amend the international treaties. That's not an impediment. When we want those treaties amended, we can get them amended. No problem. Yeah?
Is Charles Grassley involved with this? Is that the caucus on international narcotics control? Or are they different? They just look similar?
There's a direct relationship between that caucus, which is the only U.S. Senate caucus. There is no other U.S. Senate caucus. That caucus is simply there to say, are we maintaining our compliance with the treaty? In other words, you propose some legislation, they look at it and they go, you know, you've left something out, you need to reconsider because they need to review it to make sure that anything that goes through Congress complies with the international treaties. That's the agreement that we make with the international community, is that we will honor these treaties. And so that caucus that Grassley co-chairs is there to ensure that we remain in compliance with the treaties. Okay.
So they're Schedule 2. The treaty is.
The treaty is Schedule 2, but the schedules are different. They have different meanings. But you can generally say that 1 is worse than 2, and 2 is worse than 3, and 3 is worse than 4. So 2, but only THC, not the marijuana plant. There's a real inconsistency in the international scheduling, just like there is in the federal and state scheduling, okay? You have opium in Schedule 2, opium plants and coca plants in Schedule 2. You have morphine and cocaine in Schedule 2. You have THC in Schedule 3, but the plant is in Schedule 1, and it's the same way at the international level. That's a real that's an inconsistency in logic, okay? So, in other words, the argument is there to amend all of these laws. But we have to remember that we have to amend state law, federal law, and international law. We can't just stop at the state level and say, oh, we're done, we just solved the problem. That's not correct. So in 1994, the U.S. Court of Appeals approved a 5-factor test for accepted medical use. The argument there was that If something hasn't been approved for marketing, how would you evaluate that to know whether it has medical use? Because not everything is going to be approved for interstate marketing. That's an expensive process that prescription drugs go through. So they came up with a 5-factor test that doesn't rely on FDA approval for interstate marketing. And that was in '94. Now remember, in '94 there were no state medical marijuana laws, so any test would not factor state law in because there weren't any. So this test was based on science, and that's where it was in '94. It couldn't have been based on state law. There weren't any. So 2 years later, California becomes the first state to accept the medical use of marijuana, and now there are 40. So 97, my case was dismissed. They said THC synthetic, it doesn't come from a marijuana plant, you don't have any argument. So amending the international treaty allowed them to move pure synthetic THC in a pill to Schedule 3 in '99. In 2001, the U.S. Supreme Court said there is no medical necessity defense because the Controlled Substances Act is about medicine. So if the Controlled Substances Act, the schedule says it's not medicine, then you can't possibly make a medical necessity argument because it's already been ruled invalid by the fact that it doesn't have any medical use. And our Iowa Supreme Court adopted that reasoning in 2005 and said that if there was any question about marijuana's medical use, the Iowa Board of Pharmacy would resolve it. So I immediately started feeling like I should be going after the Iowa Board of Pharmacy because they were targeted so specifically by the Iowa Supreme Court in that case that I thought that was worth going after. So in Gonzalez versus Raich, the argument was that the Federal Controlled Substances Act overreaches and interferes with state sovereignty in the 10th Amendment, or that they didn't have Commerce Clause authority. And the Supreme Court said, no, Congress, federal law preempts state law. Congress can have a piece of this, and it's a legitimate exercise of congressional authority. But they said the scheduling might be invalid. In footnote 37 on page 28, they said you might want to look at the scheduling to see if that's valid. Well, of course. So in 2006, Gonzalez versus Oregon, the assisted suicide case, that one's, the DEA tried to say you can't prescribe drugs to kill people. That's not a legitimate use of controlled substances. The Supreme Court said the state decides what legitimate use of controlled substances is, not the federal government. So that's the whole argument right there. So I immediately called a meeting. This is our second meeting today. The first meeting was in October of 2006. So this is a little review. And I met with the ACLU of Iowa, and we decided to go after the Board of Pharmacy. In 2008, I filed a petition with the board. They denied it. We went to court. Judge Novak said that we had caught them in a legal error. They said that Schedule 1 required evidence of abuse potential, and you've already heard the other speakers talk about how that's not relevant because Schedule 1 and Schedule 2 are the same abuse potential. So the court said the board can't ask you for evidence of abuse because it's not relevant. And Schedule 2, they could pick another schedule that has the same abuse potential. So after that, the Board of Pharmacy was embarrassed and they decided to look at the science. So they held 4 months of public hearings and took testimony. Bob testified there. How many people testified at that hearing, Nate, besides Bob? No, this was in 2009, from August to November of 2009. So then they ruled unanimously that it has medical use. Okay, so I achieved my goal. My goal was to get them to undercut this Supreme Court decision in Iowa versus Bonnier. They did that, and now we don't know what's going to happen the next time somebody tries to make a medical necessity defense in an Iowa court. We do have somebody doing that, but they didn't really make the argument based on the pharmacy board ruling, the McKenzie case. And of course, he died while the appeal was pending, so his wife is, but they've got so many other issues, search warrant, I mean, they've got a million issues in there, and they didn't really base their argument on the pharmacy board, and they definitely didn't listen to me. I was trying to tell them. And so anyway, then you have the case that I was telling you about that we filed in 2002, and because the petitioners asked the DEA to look at science, they applied the 5-factor test from 1994, and not one word was mentioned about all these state medical marijuana laws because nobody asked the court to look at that.
Very frustrating.
So when I won my board of pharmacy case in 2010, I withdrew from the coalition, sent the DEA and everybody a letter saying, I withdraw from these people, they're not making the right argument, the argument's federalism, they won't make it, so I have to withdraw and represent myself. I was allowed to intervene in the case by the U.S. Court of Appeals a couple times. The DEA tried to move to dismiss me, and the court just didn't ever rule on those motions. But when the case was decided, they never addressed my argument. And the reason why is because I brought my argument in after the case had already gone through the administrative agency. I was bringing my federalism argument in the middle of an appeal, and it wasn't in the record of the administrative action on the case. The DEA was never given the opportunity to address my argument on state laws. And of course I knew all that was going to happen, but what can you do? I mean, I had to have my opinion injected into the case. I did that, and then I went to the U.S. Supreme Court with it and filed my own appeal on it, and several national groups. Normal has my petition on their website under scheduling cases, and Medical Marijuana Pro-Con has a copy of my appeal. So it's valuable just for educational purposes. And then last year, Iowa enacts a CBD law, which is possession only, and it expires in 2017. So the single convention looks like that. And you'll notice something odd about Schedule 4. It's, you would think that Schedule 1 would be the worst and 4 would be the best, but for some reason, this is early on, you see 1961. What I think happened there, I don't really know, but it looks to me like they were going to have 3 schedules, and as an afterthought, they just decided to add one for really nasty, to really be nasty. So Schedule 4 says the liability of the substance is not offset by any therapeutic advantage. Opium plants and morphine were in Schedule 1, coca plants and cocaine were in Schedule 1, but marijuana and the cannabinoids were placed in Schedule 4 and Schedule 1. So I really think that was an afterthought. I don't think marijuana was part of the whole thing until the last minute, and they thought, how are we going to deal with that? We hate marijuana so bad, it causes people to go psycho and whatever. So that's that treaty, and that's the treaty we're talking about. Now here's an interesting thing. In the enforcement clause, it says that the enforcement is subject to constitutional limitations. Constitutional limitations, legal system, and domestic law. So that means that the enforcement is limited by these constitutional things. If the states have legalized marijuana and it's constitutional, this treaty says it can't be enforced. That's what that says. So there's no impediment there. There's no, absolutely nothing to prevent us from saying that's an exception to the treaty, so we're in full compliance with the treaty. We haven't violated the treaty. That's what Grassley needs to know.
Yes.
You know, I mean, since he's the guy that's going to determine whether we're in compliance with the treaty, yes, we are. And he was invited to be here today and said he couldn't be here, and he's calling me tomorrow. So that's the guy I want to talk to. So that's the treaty. So what is federalism? Federalism means that Congress has to clearly express its intent to nullify state law. because the usual balance of federal and state power is that the state retains the power and that the federal government has to clearly demonstrate compelling need and clear language showing that it has invalidated a state law. And we know the federal government hasn't lifted a finger to invalidate any of these 40 state laws. So just by that, just by practice alone, you can see the pattern is that they don't think that they have the authority to nullify these state laws. And they don't, clearly they don't. So then you have the Colorado Supreme Court. Remember that people of Colorado voted to make marijuana medicine in 2000. They amended their state constitution. Here we have a ruling from June of this year from the Colorado Supreme Court that says medical use of marijuana is not lawful in Colorado. Well, how could that be? Well, because federal law says it's not medicine, that's why. So whatever the voters thought they were voting on, this is what they got. They thought they were voting to make marijuana medicine, but what they actually got was a mess. They didn't get the job done. Now, because of brute force, the law of brute force, the federal government can't stop the states from doing this. So that's why you don't see a whole lot of enforcement. But if some guy gets fired from his job and says, hey, the state law says I can use pot, you lose. You're not protected.
I haven't seen that goofy thing you just showed us ahead here. Did they harm us with that? Yeah, that thing, that Brandon code, did they hurt us with that?
No, they just,
terrible.
that's just the truth. I mean, that's exactly correct.
I mean, it's confusing me.
What the court is saying is that you can't just pass state laws when you have a federal law that says you can't do something and a state law that says you can't do something.
Okay,
You have to change both state and federal law to be able to claim that as a lawful activity. It's not lawful if it's a federal crime.
in other words, that's agreeing with the idea that federal law is through state.
It's just telling the people that whoever wrote your ballot initiative should have thought harder. They didn't think very well, and they were obviously not in their right state of mind when they wrote this ballot initiative. And that's what I'm saying, you know. You hear all these objections from our state legislators here saying they don't understand this stuff. Well, that's because it can't be understood. It doesn't make any sense. It's not their imagination. It really doesn't make any sense. Yeah?
So if Iowa passes a law saying you can use cannabinoids for medicinal use grown in Iowa, they have to specify grown in Iowa since you can't import it from other states. Is it legal to grow under federal law?
No.
Okay, so basically you have to change federal law, period.
Yeah.
Well, you got the intrastate thing going on. If the state, intrastate, and the state declares it's legal medicine, that'll protect you from the feds.
Not without saying that.
Not without notifying the federal government.
Yeah, or even just saying it in the state law. I mean,
That's what
you could skip notifying the federal government, but if you have it in the text of the state law that says we're making this legal under federal Schedule 1 for medical use, which invalidates federal Schedule 1, that's enough to give somebody like this poor guy a legal defense.
Yeah.
He could have argued that to the Colorado Supreme Court, but it wasn't there in the text of the amendment. The Colorado voters didn't vote on that. They didn't vote to invalidate federal scheduling, but they would have to. I mean, the voter goes to the poll and says, oh, medical marijuana, yeah, I'm voting for that. Are they thinking, but not federal? I don't think it's medicine under federal law. I just think it's medicine under state law. And I want to see everybody that tries to use this stuff threatened with federal prosecution. That's absurd.
There was so much noise about that stuff.
Yeah. Well, anyway, that's what's going on.
So basically what we're going to have to do is reschedule under federal law, medicinal marijuana, make sure that we pass a law in Iowa to legalize the rescheduling.
Well, my senator, Jack Whitver, has drawn up the amendment that addresses federal scheduling. He had the Legislative Services Agency draft it, and I have a copy of it with his name on it. That's what we need to do. You won't see that language in any state medical marijuana bill. And when I showed that to Congressman Young, he said, Whitford did that? And I said, yeah, because I explained it to him and he gets it.
Didn't SF 45 have that amendment?
Huh?
Did they add that amendment to SF 44?
No, the Republican caucus rejected it and Whitford didn't file it because he couldn't get consensus in the Republicans. So it was never filed. But it was drafted at my request by my senator, and he put his name on it, and that's the argument that we need to put in our state law. And if we don't, then we're just as crazy as the other 40 states, and we're going to put people in harm's way who don't deserve to be treated that way, and they're going to be the least likely of able to defend themselves. This guy's a paraplegic, this Coates guy that got fired by Dish Network. Yeah, so he got ground to dust under the train.
So here's a question, so if you have that amendment in a state law, and something like this happens with Brandon Coates, he can go and that can be protection for persecution under the federal law?
It would be an argument
Yeah.
that he couldn't make,
Yeah.
that he could have made. And I think it would have been a
So the
winning
argument would have
argument.
been basically, hey, our state has already notified the federal government that the schedule is wrong,
Right.
and therefore that's the basis of my defense.
Right, so when the voters went and voted, they voted on something that said this is legal under both state and federal law instead of something that just says it's legal under state law and ignores federal law as if we lived in the country of Colorado. Like, the states voluntarily joined the United States for their mutual benefit and protection. They can't say they're not part of it now. I mean, that's done, you know? So anyway, that's that case. And then I underlined this word rule there because I want you to understand what regulations are. Rule and regulation are interchangeable terms. They mean the same thing. The Attorney General has rule-making powers to fulfill his duty under the Controlled Substances Act, but the specific respects in which he's authorized to make rules instruct us that he's not authorized to make a rule declaring illegitimate a medical standard for care and treatment of patients that is specifically authorized under state law. This is what I base my whole argument on, is this case. Yeah.
Is that the Oregon Attorney General, or is that the Attorney General of the United States?
Well, it was both. The Attorney General of Oregon told the Attorney General of the United States, you can't tell us what to do with drugs in our state, we tell you what we do with drugs in our state. And the Attorney General of the United States says, oh yeah, well, I'll sue you. And the state of Oregon, or no, the Oregon says, well, Oregon sued the Attorney General of the United States and they won. Because the federal government doesn't have the authority to define medical use. What's accepted in Oregon may not be accepted in Illinois, but that's accepted in the United States because Oregon's in the United States. So the 70 Controlled Substances Act looks like this, state and federal. It's Schedule 1 through 5. And 1 is the one that says it's not good for anything. Opium plants and morphine are in Schedule 2. Coca plants and cocaine in Schedule 2. Marijuana and the cannabinoids were placed in Schedule 1. And since then, THC has been downgraded twice, so that it now sits in Schedule 3. So the principal psychoactive ingredient in the marijuana plant now sits in Schedule 1 while the plant in Schedule 3, while the plant sits in Schedule 1, and opium plants and coca plants don't have that inconsistency. So this is the anti-preemption clause in the U.S. Controlled Substances Act. It says, no provision of this subchapter shall be construed as indicating an intent on the part of Congress to occupy the field in which that provision operates, including criminal penalties, to the exclusion of any state law on the same subject matter, which would otherwise be within the authority of the state, unless there's a positive conflict between that provision of this subchapter and that state law, so that the two cannot consistently stand together. There have been several state court rulings on that, and they all agree that there's no positive conflict between state and federal law when it comes to state medical marijuana laws. Yeah?
Are there any other plants that are busted up within the schedules of the chemical, I'm probably saying it wrong, plant versus the actual component.
Well, yeah, you didn't quite state it correctly.
Right.
There's no plant where the extracted chemical is in a lower schedule than the plant, except for with morphine. Morphine is in Schedule 2, and the opium plant is in Schedule 2. There are other opiates that are in lower schedules.
Okay, my question on that is, why couldn't you make the argument that it is biased categorizing if there are no other plants?
I did. I made that
Okay,
argument,
alright.
took it all the way to the U.S. Supreme Court and
Right.
lost because they said the chemical was made synthetically. But CBD is not. Remember, we just went through this whole
Right.
thing about Sativex and CBD. So
Right.
now I can come back with that same argument whenever we start getting into if the DEA actually ever tries to reschedule any of these naturally extracted chemicals, then my argument just comes right back and say, oh, you denied me last time because you said it was synthetic. Now it's not synthetic. Now what are you going to do?
Okay, all right,
So,
Okay.
yeah, I'm ready for them.
Okay.
I'm going to jump on
It's
anything
good.
I can,
But
any
it's
little
irrational.
thing they do wrong, I'm going to jump all
Well,
over
I
them.
just thought it was irrational categorizing in which it is, but okay.
Yeah.
Okay.
So, yeah, the main thing about Schedule 2 is it's accepted medical use.
Right.
So it's not difficult to say, well, we're going to extract some stuff and use it for medicine. The plant's classified as medicine, but marijuana has no medical use. So what we're doing is trying to identify the cannabinoids and make them synthetically to avoid rescheduling marijuana, which is absolutely laborious. It's like mind-boggling, but that's what we're doing. Okay, so that's the anti-preemption clause. In case anybody was wondering about federal preemption, there's an anti-preemption clause in the Federal Drug Act. So it says the Attorney General may by rule transfer a substance or remove, look at this, remove a substance from the schedules by rule. So if the Attorney General can't make a rule that invalidates the state medical marijuana law, how could the Attorney General maintain a rule, which is Schedule 1, and not remove it from that schedule? It's the same argument. It's a rule. Yeah.
So the Attorney General of the state of Iowa has the authority to reschedule?
No, this is federal law.
Okay.
Yeah, that means United States Code. That's what that abbreviation is for there.
So the Attorney General of the United States has that authority vested in him?
Right. We don't have that authority at the state level. The authority is the Board of Pharmacy makes a recommendation, the legislature decides. So at the federal level, it's the Department of Health and Human Services makes a recommendation to the Attorney General makes the decision. At the state level, it's the Board of Pharmacy that makes the recommendation, and the legislature decides whether to reschedule. But it doesn't make sense that the legislature told the Board of Pharmacy to do this, and then when they do it, they ignore them. That's the weird part about it.
So we need to petition the United States Attorney General to reschedule?
Well, a lot of people are doing that.
Okay.
I mean, I don't want to say no. I mean, you can do that, but it's already been done, it's being done. The states of Washington and Rhode Island are doing it right now.
Okay.
But they're basing their argument on science and won't base it on federalism. The doctor that wrote the thing testified before the Board of Pharmacy here in Iowa in 2009, Dr. Greg Carter. They told the governor of Washington that they should talk to me before they file a petition. We exchanged a series of emails where I told them you need to take it out of your state Schedule 1. You can't ask the DEA to move it out of federal Schedule 1 when you have it in state Schedule 1 at your own state. And they said, no, feds go first. I said, no, states go first. And that was the last exchange. So I had a lengthy argument with the governor of Washington before she filed this thing, and she filed it against my advice, based on science. Yeah.
Who's the current U.S. Attorney General?
Loretta Lynch.
Just doesn't ring a bell.
Okay. All right, so there you are. That's the duty that the U.S. Attorney General has Here you are under section 811, and it says, rules of the Attorney General under the subsection shall be made on the record after an opportunity for hearing pursuant to the Administrative Procedures Act, that's what Title V is. Proceedings for the issuance, amendment, or repeal of a rule may be initiated by the Attorney General, the Secretary of Health and Human Services, or the petition of any interested party. So the question here is, who is an interested party? Well, I'm an interested party. Right. And so is John Getman and High Times, right? But they don't have standing to appeal. So what good does it do you to file a petition if you can't file the appeal? If they deny the petition on some ridiculous grounds and you don't have standing to appeal, that's really hard to handle.
Who did they file the petition with?
Pursuant to the Administrative Procedures Act, you file a petition. The section is 21. Title 21 of the Federal Code of Regulations, section 1308.44 is where you will find the application form.
So you can't file it just straight to the Attorney General? It has to go through what?
Well, the Attorney General has delegated his authority to the U.S. Drug Enforcement Administration, which is a branch of the U.S. Department of Justice.
Well, that's something they could do.
Well, that's not the point. The point is that you can't appeal if you file one of these things. That's the point here. So who is an interested party that would have standing to appeal?
The state.
The state government would have standing, you bet they would, because it's a violation of federalism. Absolutely. So it's deceiving to look at this because it's not just an interested party, it has to be an interested party who also has standing. And that's the trick to the whole thing.
Yeah.
So here's the section on Schedule 1. The drug or other substance must have no accepted medical use and treatment in the United States. So I've underlined that word, in the United States, because apparently we don't think 40 states are in the United States, right? 40 states have accepted it, but it doesn't have accepted medical use in the United States. So the United States must be, is that Jupiter or Saturn, or where is the United States? I'd like to know. Get a map and show me. So, here's a question. What does in the United States mean? There's 4 answers there. How many think it means A? Okay.
It should be.
How many think it means B? How about C? And how about D? Okay, I got 3 hands on A and nobody on the other 3. So A is the popular response. A is the correct response. So congratulate yourself if you got that quiz right. Here's a case that was decided in 1987 that I talked about earlier, where they discussed what does in the United States mean. This is a U.S. Court of Appeals for the First Circuit. The administrator was saying that it doesn't mean intrastate medical use. He was saying it has to be accepted in all 50 states to have accepted medical use. And the court said, we find this language evidence that Congress did not accept medical use, intend accepted medical use and treatment in the United States to require a finding of recognized medical use in every state. So that rules out answer C. It's not in all the states. And it doesn't require approval for interstate marketing. So that rules out that whole process. Then they said, unlike the CSA scheduling restrictions, the FDCA interstate marketing provisions do not apply to drugs manufactured and marketed wholly intrastate. Thus, it is possible that a substance may have both an accepted medical use and safety for use under medical supervision, even though no one has deemed it necessary to seek interstate marketing. So how would you know if a substance has intrastate medical use?
State law.
What higher authority could you have than a state law? So all you need is a state law with a statement tying into this case saying, we have just invalidated Federal Schedule 1 because this has accepted medical use in the United States because we say so, because we're a state, and we have the authority to say it. And here's a federal court decision that explains it. And I already went through the other U.S. Supreme Court case where it said that states have the right to define medical use. So you have two of them. Two cases, federal cases, one from the U.S. Supreme Court and this one from the First Circuit, both saying the states have the right to do this. So the only thing is missing is that we're not saying so. We're enacting these state laws as if they're inconsistent with federal law. And that's what has everybody scratching their head. How does that make sense? It doesn't. It makes no sense. We should not do that here in Iowa. We should tell the federal government that we've accepted this for medical use. They can take it out of Schedule 1 and we'll file a lawsuit against them like Oregon Gonzalez versus Oregon. The Attorney General of Iowa can sue the federal government and say, we're going to enjoin the enforcement of your Federal Schedule 1 until you figure this out. You're not enforcing that here in Iowa. Yeah.
Would the state first have to reschedule candidates though?
It would be absurd for the state not to reschedule. The thing, like I went through with the governor of Washington, where I said the state goes first, and they said no, the federal government goes first, it's really simultaneous. The state reschedules and says we've just rescheduled under federal law at the same time. There's no, this one goes first. It's all one thing. It's all one package.
Remind me, your rescheduling amendment, your amendment to notify the federal government on medical marijuana, does that include rescheduling at the state level?
No, because they passed rescheduling at the state level 44-0 on that bill. So that was already done.
Okay. But our CSA hasn't been amended in the state. I know that you did that through the Board of
Right, the Senate voted on it as an amendment to Senate File 484, which passed 26-24.
Yep.
The amendment to reschedule passed 44-0 to 6 absent.
Yep.
So the will is there. They understand that it can't be in Schedule 1, no doubt about that. But they don't get this federalism piece of it so well. So we've made progress. I can't say that my work has been for naught. So going back to this case in 1994, this standard was developed in the absence of any state law accepting the medical use of marijuana. So you can see those are all scientific questions. Okay, and these are questions that our Iowa Board of Pharmacy looked at. They did examine the science. Even though we didn't tell them to avoid my argument, they decided they'd rather look at the science than rule on my federalism argument, and they ruled unanimously that marijuana is medicine based on this test. So even this test is just fine.
But it didn't work. I mean, they couldn't drink it all. We had to throw it out.
Pardon me?
Well, yeah, are you talking about that federal case you were joined to?
That case.
No, you weren't.
That case was, ended up saying there haven't been sufficient clinical trials.
Yeah, that's kind of my point. The science failed in that, and we.
Yeah, the bottom line in that case was they never asked them to look at federalism. They said they wanted them to look at science. And the DEA said without sufficient clinical trials, phase 3 clinical trials, which only happens with pharmaceutical drugs. Remember that this test was developed to get around the whole idea that you had to have the FDA marketing approval. The clinical trials are all part of that process. So somehow we went backward from this and went to the more restrictive standard that existed before this one and went back to the clinical trials, which is a total backward from this. It's not forward, it was backward. And I tried to object, and I should have made my argument in 2002 when the petition was filed instead of in 2010 when the thing was in the appeal court. So here's 40 states and 3 federal territories have accepted some form of marijuana, either an extract from the plant or the plant itself. All inconsistent with federal scheduling, every single one. And nobody nobody knows what to do. So, to get elected to office, you have to know nothing about federal, anyway. The reason why our politicians don't solve this is they have more to think about than marijuana scheduling. I mean, that's just the reality of it, so.
I'm sorry.
Yeah.
With our CBD oil law, anybody in the state and from the state government, wouldn't we still have to reschedule here in the state before we petition the federal government?
Well, the inconsistency of the thing expiring in 2017 is going to be a roadblock.
Okay.
That's going to, like, the whole scheduling thing just doesn't make sense. If we're just temporarily allowing it, it's like,
We're not actually, so.
that's not very,
So is the answer yes, we would still have to have a new bill that includes the rescheduling amendment?
we'd have to have a new bill.
Okay.
And I think I sent you the article today out of the, what was that? It's something out of the University of Iowa, some journalism project. There's an article. It had Breitbach in it, anyway. And it had Shelgren,
Yeah,
and Bolcom.
yeah.
And Shelgren says,
Federal scheduling has to change before.
Yeah. and Breitbach said,
We're gonna do something
we're going to do something
this year.
this year. So I am really curious.
Funny, you got excited about that part, and I got discouraged by the other part.
I want to know what Breitbach's going to do.
I've heard from a number of the Republicans that they're planning on doing something. But I don't know.
I have heard that too, but now I got a name. I'm going to write that guy and say, what are you going to do? I want to know what you, I want to know what you just said in the newspaper there. I want to know, what is this that, you know?
How do we insert me so I can talk to my fellow Republicans?
Huh?
How do we insert me, some guy just write him? Is he a state rep or something?
Well, the first thing I run into whenever I talk to a state representative is like, have you talked to your guy? And of course I have. I've nailed Kester for an hour. I made Kester sit down with me for an hour. Whitver and Schneider sat down with me for an hour the day of the vote in the Senate. Congressman Young sat down with me for 45 minutes last month. Senator Grassley's calling me tomorrow, or he's calling me on Monday. But
This is wonderful.
yeah, so when I go to talk to these other guys, well, one of the things I do when I talk to my guys is say, who should I talk to? And then when I go talk to them, I say, my guy told me to talk to you. That's a nice introduction. That way they can't even ask you if you talk to your representative, because you're just throwing that out there right away. With this, I'll just send a copy of Senator Whitver's amendment with my letter to this guy, showing him that I've already been working on this, to show him that I'm not just coming out of nowhere.
How do I support you? How do I contact these people? Who do you have to contact?
Well, you need to start with your guys. And that's difficult. Like in the past, they refused to talk to me. Now, for some reason, they're interested. I don't quite understand that. You have to move when
I'm public pressure.
the public pressure is unbelievable. The opinion polls are going skyrocketing. We're over 50% on full legalization now. So now the question is no longer if, but how. And I have the how. I don't really have the if. That's already been done for me. I don't need to, the public is doing that for me, but I have the how, and that's what is missing. So here's a case, typical case where somebody tried to challenge federal scheduling, and the court says there's a long litany of cases finding the scheduling rational. Defendant's claim is not novel. Since the CSA was first enacted, it's been challenged in many courts and many circuits. To date, every court has held, every single one has held that the CSA Schedule 1 is rational. So it comes down to your question about how do you know when you've crossed over and it's no longer rational, and it's always like a substantial majority, but we don't know what that a substantial majority actually means. There's no like hard math, there's no hard numbers to tell us when we've reached that threshold. So that's the rational basis analysis that they use in all of these cases. That's how they do it. So, and they say they set up an agency procedure for this. So here you are in court. court, trying to make this argument in district court, and the court's saying, why didn't you go to the agency first and ask them for permission to sell that pot? You know, Congress set up this process, why didn't you use it? Okay? Congress has entrusted scheduling to the DEA, not the courts, for ad hoc decisions in every federal prosecution. This is not merely a rational decision, but a decision pivotal to achieving the goals of the CSA and the practical operation of the trial courts. It's hard to imagine any other process that would provide the flexibility needed to change the scheduling in light of ongoing scientific development. The uniformity needed for national drug policy and an orderly enforcement process. The court, now I love the footnote. The court does not agree that Congress's decision to delegate scheduling decisions to the DEA deprives the court of subject matter to evaluate a constitutional challenge. That's what my argument is. It's a constitutional challenge. The defendant didn't make it. The defendant didn't make my argument, so he had no constitution. He invited the court to apply the rational basis test, which is, you might as well, the lawyer made money, but the defendant, and the lawyer probably didn't tell the defendant what a stupid idea that was. He probably just thought, I'm collecting a paycheck here. So, that's the key. I have a constitutional challenge, and it doesn't deprive the court of jurisdiction like all this scheduling DEA stuff does. So the court left open the constitutional challenge without telling you too much detail. They don't want to help you too much. So you have to figure out what that means.
It's got a however on there.
Yeah, the however is that the court has to respect the mechanism that Congress set up to change the scheduling, which is true. Of course they do. But if there's an argument that has nothing to do with evaluating the science, then that's not something the procedure contemplates. It's a legal argument.
So after I wade through a couple of these double negatives here, the feds are saying that the DEA is in the driver's seat, and the court is saying, not really.
Yeah, the court is saying if you're going to make an argument based on science, you're in the wrong venue. You need to go to the DEA.
That's an agency issue.
Yeah, that's an agency issue. If you have a constitutional argument, let's hear it. Well, stop. You can hear crickets chirping. No constitutional argument, so you're off to the DEA. And you can go sit in prison while you think about it. In prison, you can go read some law books. Maybe you can figure this out. So, if the court had to determine in each separate drug prosecution whether Congress or the DEA acted rationally in every scheduling decision made, the courts would be overwhelmed. Congress, on the other hand, is the last time anyone has ever won one of these administrative rulings on science. And the way I won was don't show them any science. Give them a constitutional argument that freaks them out, and then they'll do an honest job. So, on Gonzalez versus Rage, this is the case where they said Congress had the right to preempt state laws. And they said, we acknowledge that Schedule 1 might be inaccurate. And if the evidence presented at trial had shown that, then it would be unconstitutional, or it would be illegal to keep it in Schedule 1. Now, we just went through a whole litany of cases that say you can't make that argument in a trial court, but here's the Supreme Court saying the evidence of medical use, if found credible after trial in a U.S. district court, would cast serious doubt on the accuracy. So a court in California said, we're not going to pay any attention to this litany of cases that haven't allowed this argument in court. We're going to let the argument come in. And we're doing it based on this footnote in this Supreme Court case. It looks like the Supreme Court is saying this is an issue for a trial court. Doesn't matter how it jams up the court system. So the judge allowed the trial in district court, and guess who the lead witness was? Dr. Greg Carter from Washington, our buddy from Washington that won't listen to me on the federalism argument. And lost on the rational basis test in district court. Same result. It wouldn't matter if you'd gone to the DEA, you get the same result. Rational basis test, you lose. So Dr. Carter is not the most astute legal student. He's a pretty good doctor, but he doesn't know nothing about law. So, here's a statement that was made at the caucus before Senator Grassley on the June 24th. The DEA says CBD's in Schedule 1. So that is a statement that will stand unless challenged. And that's the end. And that's how you can contact me. And any questions? Yeah.
I keep seeing it, and I'm not used to seeing it. What's cannabis sativa L?
I don't know. It's a Latin name, technical name for one of the three.
There's cannabis sativa L, and there's cannabis sativa indica, and cannabis sativa afghanica. It's all how they respond to the different environments where they're grown. So afghanica is obviously from Afghanistan, indica is from the Hindu Kush Mountains in India originally, and the cannabis sativa was typically, I believe, grown in lower lands closer to the equator.
Would it be fair to say people come in different colors?
Yeah, it's the same thing. It's people come in different colors.
So
Cannabis.
sativa.
Different botanical classification.
Yeah, I mean, for a crude example is a lot of the afghanical plants are going to be short and fat because they're indicas, and then the sativas are tall and skinny. That has to do with the amount of light getting to them, the topography, the climate, the humidity, and
I
everything.
go on with the geography. So ruderalis is a sativa.
Huh?
Ruderalis is a sativa.
Yeah, ruderalis. Well, if you want to get technical, I'm not the guy to get too technical about it. But there's actually been a study recently released that says that there are no more ruderalis plants out there, and it's really everything's a combination of Afghanica, indica, and sativa.
We have about 3 minutes left, so.
Yeah. So that's a conversation for another day.
Yeah, sorry. Yeah.
So as somebody currently being prosecuted by the state of Iowa for possession of a controlled substance, how, and I'm not asking for legal advice necessarily, but I'm asking, what do you think about the possibility of making the sorts of arguments you're making right now in court?
That's a tough question. One of the things that comes up is like the defendant says in federal court, the defendant says, I'm being prosecuted for medical use and that, and the court will say, were you in compliance with the state law? And if the defendant wasn't, then the court's going to say, well then, you're out, you're just wasting our time. So, I don't know how you would make that argument at the state level that you are in compliance with anything.
What about the argument that Schedule 1 is invalid and that the case should therefore be used?
Well, I would encourage you to make that argument, but I don't want to get your hopes up either. I mean, you probably lose on that argument, but it would generate some head scratching that I just think that since you're in the position where you're kind of defenseless anyway, why shouldn't you make all these arguments? I mean, let's just say the court rules the argument invalid, but then the sentencing comes up, maybe the judge says, you know, this whole thing stinks. I'm going to give you a light sentence because you've explained how absurd this whole thing is. That's in there. So I don't want to tell people don't make these arguments, but I do want to let you know how difficult it is.
Just looking back at Mackenzie, he wasn't even allowed to testify towards his medical use because of Schedule 1, so it depends on the judge too. It really depends on the judge.
Yeah, the more information you can get out, the more you have this jury nullification thing in the air, you know. I mean, the more that the court and the jury sees the unfairness of the whole thing, the better off you are. You have to be polite while you do it. It's really hard. I mean, when I was being prosecuted, I just felt like these people should all be in jail and I should be free, and what the Well, I'm just saying, it's really hard to be objective when you're under fire. All right, well, thanks for coming.